All right. So, welcome everybody to today's Legally Speaking podcast live. It's proudly sponsored by Clio. And let me start by asking a bold question. Why are even the best professional services firms with world class policies, top tier lawyers, and huge reputations still sued for millions, potentially even billions? Today, I'm joined by a remarkable guest in the amazing Shaun Tracy, who's a counsel at Campbell's and the very proud author of The Advisor's Minefield: Why Professional Firms Are Sued and How to Protect Your Practice. Shaun has advised on billion-pound contracts, defended some of the largest professional liability disputes of our time, and written 2 books equipping advisors with the tools to protect themselves. Beyond the courtroom, he's also promoted arbitration networks across the Caribbean and represented the Cayman Islands at the Chess Olympiad. So, a very big warm welcome to the show, Shaun.
Thank you, Rob. Thank you for that warm welcome. Delighted to be here today.
Oh, honored to have you, and what a background. So, I guess let's jump straight into it. Can you share a bit more about your background from training at Simmons and Simmons through to moving offshore and building your career at Campbell's?
Yes, sure. Originally, I'm from Derby in England, and I moved to London in 2003 for professional training with Simmons. And I was then with the firm through till the end of 2011. During that time, I actually qualified into the commercial projects team. So we were acting on major contracts. We had clients like the Ministry of Defence and Railtrack. And but over time, fairly quickly, I transitioned into litigation and then spent much of my time at Simmons handling high value professional liability cases. And I would say around 80% of those were claims against law firms.
Yeah, it's a staggering kind of percentage of what you're involved in. And I want to talk about the earlier stages because you worked on the Ministry of Defence 13 billion air-to-air refueling contract. So what did that experience teach you about working on high stakes advisory projects so early on in your career?
It certainly did feel like being thrown in at the deep end, although in a good way. I mean, junior lawyers want that kind of exposure. They want to be thrust into the middle of a negotiation. And it was certainly like that. It was very, very large contract. It took 5 years to negotiate. So my part was a tiny fragment, really, within the middle of that. But it was a contract to deliver a fleet of air-to-air refueling tanker aircraft for the Ministry of Defence and a public-private partnership. So the main theme during the negotiations was what risks should the contractor take and what risks should remain with the government effectively. So in a typical negotiation meeting, I would be there. I'd be together with a representative from the RAF, and on the other side, we'd have a representative of the contractor and then their lawyers, and we might be discussing things like should the government or the contractor bear the risk of a bird strike, where an aircraft is simply taken out of the sky through a flock of birds swarming into the engine, this kind of thing, of which, of course, I knew nothing about. But my role there was to assist the RAF in their discussions and to make sure that whatever was negotiated was reasonable and was then properly reflected in the contract.
Yeah, I love that. I love that little story you give, and it's a great little nugget there. Sometimes being uncomfortable is the best place for growth, and like you said so early on, you probably equipped so many skills and so many lessons very early into your career that have gone on to obviously help you do tremendously well to the present day. And with that, I want to kind of switch to your writing duties because your new book, and it's a big week for you, and has been a big few moments. What motivated you to write it, and how is it different from a traditional legal textbook? Tell us more.
Well, thank you. Well, a traditional legal textbook tends to be long and tedious, and my book is deliberately short and it's meant to be engaging. The the other difference really is a textbook tells you what the law is, but my book really isn't telling you what the law is. The law on professional liability has been addressed elsewhere. The purpose of the book is really to explain to professional advisors, in particular lawyers, but also accountants and brokers and so on, um, what are the real world risks? Where did the claims come from in real life? And how could they have been avoided in many cases? So, you asked me also about motivation. Why did I write the book?
Yep.
Well, over those many years defending professional firms, my client is the professional firm and their insurers. But in reality, it's also the individuals. the advisors who've been accused of making the kind of major mistake that may have cost millions or even more. And so these clients are highly successful people. We're talking rainmakers, senior partners, sometimes hot 100 winners, but they're at their lowest ebb because they've just been accused of a negligent mistake that may have cost the firm millions. So if I can share my experiences and insights to help other advisors from that kind of avoiding that kind of professional crisis, that was the main motivation for writing the book.
Yeah, and I must say it's tremendous amount of effort that you've put into this book. And my next question is just fascinating because you've worked on so many fascinating cases. But could you share the story of the $1 billion ball, where I believe a single mistaken word in a contract led to an extraordinary consequence?
Absolutely. And before I do that, I'll just say that the stories that are in the book are adapted, anonymized. Sometimes the professions have even been changed, except where I've been clear that I'm talking about a real world case. But everything in the book is based on true facts. So with that caveat, the story essentially is that uh, every professional liability claim begins with a problem for the client. And the problem might have been caused by the advisors, caused by the client, or simply bad fortune. But in this case, the client faced a problem that they were purchasing the remaining shareholding in a football club to own the club outright. And they had bought their initial stake some years earlier, and they bought it under a contract whereby there was a pricing formula that took account of profits in the meantime. And so when the client came to pay the price for the remainder of the shares, their view of the price and the other side's view of the price was completely different. One of them relied upon the contract and said, well, hang on, this formula produces $2 billion, whereas the client's view was that they should be paying 200 million. So there's a delta of $1.8 billion there, all based upon interpretation of the contract. And in fact, the contract was clear and the opposing party was right. So it meant the client had a problem that they were facing a demand to pay $1.8 billion more than what they bargained for. So this then translates into a claim against the professional advisors. All of the attention is turned to the drafting of the contract. And on the advisor's files, we see a handwritten amendment to a draft contract where a single word has been changed, and that single word has the $1 billion consequence. So the claim is made against the advisory firm. And in the book, I'm not simply recounting this as a case study in a sort of dry manner. I've made it so that I'm interviewing, which is effectively true, that through the book, you will see what it's like for me to interview the advisor accused of the $1 billion mistake, how they explain what went on, what their response to the claim is, the counter arguments put to them. So in my role as a defense counsel, of course, I see their files, I review the files, I consider the claim, and then I conduct those first interviews where I try to draw out from them what has happened and then to build the firm's best defense. That involves a sensitive task. It's a great responsibility to be working with these clients, defending claims of such magnitude. But it also requires me to ask the tough questions because they will be asked by the other side. So in this case, the handwritten note is on the file. It was acknowledged that this was in the handwriting of the associate concerned, but there was no explanation. There was no email saying from the client, please make this amendment. There was no email going back from the advisor saying, we've made this amendment. And there was no file note. So you then get into a classic and really awful scenario of it being the client's word against the advisor's. So the client is saying, this is your fault. You made that amendment without us having instructed you to do so, and you've caused us a loss of $1.8 billion. Whereas from the advisor's side, their instinct is they cannot remember having made this amendment. It was made 5 years earlier on a deal where the contract may be 100 pages. But what they can say is, I'm sure I never would have made this amendment had I not been instructed to do so. So you get the ding dong between the client and the advisor. The difficulty, though, is that in the absence of any notes or any corroborating evidence, the client will often get the benefit of the doubt. And this may be tested all the way up to trial if the case is not settled.
Incredible. And folks are tuning in live to this on a Monday and you think you're having a bad Monday. Think back
Happy Monday.
yeah, think back to that individual at that point in time for the $1.8 billion costly mistake. Fascinating. Thanks for sharing that, Shaun. You also describe cases where you've given clients a clear health warning that didn't prevent a claim, if I can get my words out. So what does this tell us about the realities actually of professional liability in your opinion?
Well, one thing it tells us is that even a very long-standing client, someone you may have represented for 15 or 20 years, could end up having to sue you, feeling like they have to sue you if they believe a mistake has been made and it's caused them a loss. On the other hand, there are also other cases where some clients will actually not necessarily believe that it's your fault, but they might really bring a try-on claim, a scapegoat claim. And in this case, that was very much how the advisor, the lawyer in this case, felt. So to give that a little context, again, I'll start with the client side because it always begins with the client problem. The client's problem in that case was that they'd bought a property, they'd held it for many years, it had gone up in value, but when they came to sell it, the potential buyers noticed what they said was a defect in the head lease, in the documentation. And the defect was that the ultimate freeholder could move the swimming pool in this condominium complex across to the roadside rather than being at the beach. Now, you might say, and everyone would say, why would they ever do that? And they may never do that. But it didn't mean that that legal right in the contract, in the head lease, may have devalued the head lease. And that was certainly what the market was telling this client when they were trying to sell. So they faced a roughly £6 million difference between what they thought the property was worth and what they were being told it was worth with this term in the head lease. So faced with this loss of value, the client felt compelled, or they at least decided, to sue the law firm and say that at the acquisition stage, the lawyer should have advised them that this clause was potentially problematic and that they had not done so. And so the health warning that you referred to was actually an email written by the property lawyer concerned to their client at the acquisition stage, really saying, you've asked me to do this deal in a rush. Everything has been done far more quickly than normal. It's possible things will be missed. But these are risks that I'm pointing out to you in a general sense. That's the health warning. And so jumping ahead then, why did that health warning not necessarily save the lawyer when they were defending the claim? The reason was because the health warning was not specific. And so the evidence of the lawyer was that they had met with the client pre-acquisition. They'd laid out the head lease on the table at the client's home. They'd gone through the terms. And they said that must have included this term. Of course, they didn't have an actual recollection and they didn't have any note, but that was their position. On the other hand, the client was saying, pretty much like the last example, well, I don't believe you did take me through that term. I don't think you pointed that out to me. Had you done so, then I would have seen it was problematic and I would have reduced my own purchase price by several £1 million too. So why did the health warning not work? Because it wasn't specific enough. In other words, it didn't say, I've warned you and I've advised you about these particular terms.
Yeah, and my listeners and viewers will be sick of me saying it. Specific is terrific, and I remember learning and hearing that, and it's so true. The more specific you can be, the far better off the result. And this is important, just based on the last two points you've shared there in terms of the level of details, and that's why it's important, to really check and be thorough. And okay, I want to come back now to some further lessons from advisors in the book, because you outline 5 key lessons in the book. Which do you think is the most important risk factors advisors often overlook?
That's a very broad question, and the answer could be very broad because there are many risk factors. And I would say one of the general things that the book tries to bring to readers is really to develop more like a sixth sense of where the risks lie, because there are risks in everything we do as professional advisors. I would say that there are three main reasons that clients sue their advisors. So if we start with that, the first reason is that the client has acquired an asset that turns out to be worth less than what they believed it should be worth. And we've just seen an example of that. The second reason is where the client faces a demand from a third party, a payment demand typically. We've just seen an example of that in terms of the $1 billion claim. But there are also many other examples, like tax authorities demanding payments from clients years after a tax mitigation scheme was put into effect, these kind of things. And then the third particular problem is where the client has lost a legal right. So they might say, well, but for your advice, and but for me having then taken action upon that advice, I would have had these rights, or I would not have been subjected to these obligations. So when you look at it in a framework like that, these tend to be where the claims come from. How that will then translate into any particular profession or any particular specialism within the profession clearly is more varies a lot from case to case. But there are these overriding themes. One of them, I would say, in terms of scapegoat claims. So a claim where the professional advisor is adamant that they gave the right advice, but they may struggle to prove it if they don't have notes. So one of the main scenarios where this happens is where the client has made some form of concession, maybe during a negotiation. They've accepted something or they've decided not to take some action, and they had their own reasons for that. And of course, it's not for the advisor to second guess that. It's up to the client. But the danger is that later they will say that that was done on advice, or that they wouldn't have done that but for the advice. So where a client is making a concession, giving something up, this is a major red flag, I think, in my experience.
Yeah, and again, thanks again for being so detailed and giving some really interesting insights. And you've said that sort of genuine claims rarely arise from a lack of knowledge, but more from drafting errors, which we've kind of touched on, miscommunication, which you touched on, or conflicts. So, with that in mind, why are these human factors so persistent?
Why are there still traffic accidents? I mean, humans are inevitably imperfect. Um, and the pressures and complexities of modern day professional practice, I think, is at the root of this. I would also add that even though professional advisors get generally very good training, very good experience, and are often led in exactly the right way, they don't necessarily benefit from appreciating how these claims pan out in real life and where they come from. So it's a little bit like every time they hit someone, it comes like a bolt from the blue. It could come also many years after the advice was given, in which case they then have to try and remember how the advice they were given, remember what was going on, review the file. Is the file perfect? Is it not? These kind of things. So really, it's no surprise that claims come because humans are imperfect and the complexity is immense. Having said that, the whole point of my book is that in many cases, the claims can be prevented, or at least the firm can be placed in a much better position to robustly defend a claim if it is brought. Ultimately, you can't stop a client bringing a claim if they're determined to do so. But you can do the best to protect your firm.
Yeah, and of course, everyone wants that. And you touched on it before, but just going a little bit deeper on scapegoat claims because it is another big theme. What warning signs should advisors look out for when they make maybe at risk of actually becoming the deep pocket defendant?
I would put this in two categories: risks within themselves and within their firm. For that, I would say the major risk is where the scope of your engagement is not clear, is not crystal clear. And to give a very brief example, a case from quite a long time ago that went all the way through the courts involving the Eden Project in Cornwall. So it was set up as a really a tourist attraction as the new millennia approached, eco-friendly special place. And it was set up by founders who had an intention themselves to profit from this venture. So they'd engaged lawyers, the lawyers had advised them all the way through, putting the structures in place and so on. But they'd been required to put in place a charitable trust structure because the Eden Project was obtaining funding from the National Lottery in the UK, which is a charitable fund. And what this meant was that as time went by, the funders were not entitled to take any profit from this venture because the nature of the charitable trust simply precluded that. So coming back to the lawyer then, they faced a claim for the loss of profits that the founders say they ought to have earned. And coming back to my initial point, what was the ambiguity in their engagement? Well, it really was whether they were engaged to protect the financial interests of the founders or simply to act in the ordinary course in pursuing a project on a charitable basis. And this ambiguity cost the law firm because they were held liable for not having protected the interests of the founders. That was answering from the advisor's point of view. In terms of risk from the client point of view, I would say scapegoat claims frequently are brought by opportunist clients. And if you can spot within your practice, it may be just one, maybe two, maybe a handful of clients who really would take every opportunity to shaft you if they needed to, then those are the ones to watch out for because they will turn on their advisors. They will exaggerate a claim. They will sometimes fabricate evidence, and they will be a real nightmare to deal with. So watch out for opportunist clients.
Yep, very sage advice. It has to be said. Okay, I want to now move back to some of your own case highlights and reflections on your journey, and because the book is fascinating, it's full of so many amazing stories and nuggets. But from the sort of Equitable Life trial to defending HSBC and the Madoff litigation, what lessons did those super high stakes cases teach you about professional liability?
Well, really, that a claim can hit even the most experienced, expert and competent advisor. That is the root of it. And they can pop up from anywhere. The whole gamut of business experience and life experience ends up being reflected in these claims because advisors are indeed acting on a whole range of matters with massively different backgrounds. And yet, and so as the defense attorney representing advisory firms, we see a whole range of claims coming from everywhere. In terms of the Equitable Life, that was the very first professional liability claim that I was involved in as a trainee back in 2005. And, excuse me, in the Equitable Life case, our client was a non-executive director of an Equitable Life pension company going about their ordinary professional life, minimal, let's say, modest level of involvement in the day-to-day dealings of Equitable because they were only required to have a high-level input. They would work half a day a month or something along those lines and be involved in high-level decision-making. And yet they found themselves on the receiving end of a claim worth £2.5 billion personally. And this claim was set down for an 11-month trial in the High Court in London. And the claim against the directors collapsed after about 4 months. It was simply dropped. It should never have been brought. And yet this lady client, who really was an esteemed professional and had taken on this directorship as almost one of the culminations in a career, being made a director of Equitable, it was a plum job, but it brought massive risks. Jumping forward, I moved to the Cayman Islands in the end of 2011, which of course is a major financial center and has masses of money flowing in and out in investment products and so on, which also means that when things go wrong, the values are immense. Shortly before I arrived, there was another director's case here called the Weavering Macro Fund. Essentially, the Weavering Fund was used as a vehicle of fraud to the tune of about $110 million. And the directors of the fund were sued by the liquidators once the fund went into liquidation. And they were found liable for $111 million, with an absolutely scathing judgment from Justice Jones of the Grand Court of the Cayman Islands, basically saying they'd done nothing in their role as directors. Now, that was a case where, in my personal opinion, they really got what was coming to them, and they may have been quite lucky that on appeal they were found not liable in willful default. It wasn't enough to found liability. The claimants had to show willful default, which was far higher test than negligence. They were plainly negligent. This was accepted, but they weren't, it turned out, guilty of willful default. Anyhow, probably certainly the largest case and most significant case that I've been involved in has been the claim by Primeo Fund against HSBC subsidiaries, again in the Cayman Islands. Litigation that sprang out of the Madoff fraud. And you'll sense the theme there. Quite often it is fraud, an underlying fraud for which the advisors have no involvement whatsoever, that turns into a professional liability claim. In this case, Primeo Fund was an investment fund set up in the Cayman Islands that had chosen to place all of its assets, we're talking many hundreds of millions of dollars, with Bernard Madoff. And it turned out that Madoff was perpetrating the largest Ponzi scheme ever, believed to have been worth $65 billion or so. And he had fabricated an entire book of business, something that was simply inconceivable even to industry professionals at that time. To expert financiers, this was inconceivable. And so Primeo Fund had lost all of its money, gone into liquidation, was faced with huge losses that it could struggle to recoup. It did make large recoveries from the Madoff bankruptcy, because the trustee in bankruptcy has done an amazing job in recovering almost 100% of the principal invested by garnering clawback claims, largely in the US. But it still left Primeo Fund with a massive loss of profit, according to what it had been reported, because it believed it was sitting on a couple of billion, and of course it wasn't. So the liquidators sued HSBC, which was acting in the capacity as custodian and fund administrator. And really, the claim was for $2 billion. It lasted the best part of a decade, went to the Grand Court, Court of Appeal, Privy Council. We had 30-odd witnesses, including a former director of the FBI, and massive amount of complexity, and the legal costs were off the charts. Ultimately, HSBC prevailed at the Privy Council, in fact, at every judicial level. But it was a closely fought case, highly complex, and really, it tells you that in professional liability, nothing is clear-cut, nothing is straightforward, and everything is contested.
Yeah, no, thank you for sharing that, and just fascinating stories and cases that you've been involved in over the years. Let's talk beyond the courtroom now, because you've co-founded the Cayman Islands chapter of Chartered Institute of Arbitrators and now Secretary of the Caribbean branch, I believe. So why was building and sort of promoting these arbitration networks important to you?
Absolutely, yeah, thank you. And the Cayman chapter of the CIARB was chaired by Andrew Pullinger, my colleague, who was formerly in the Cayman Islands until recently. We see it as really helping the profession, and by extension helping lay clients, because over here the tradition has very much been litigation. Alternative dispute resolution has been really on a back burner until recent years. We now have a modern, up-to-date arbitration law, and we have now institutions. We have a Cayman Islands International Mediation and Arbitration Center set up quite recently, and we have, of course, the CIARB. So these give advisors and clients alternatives in the way, as the name suggests, in the way they handle disputes. And from a professional liability point of view, we can see a real benefit in terms of confidentiality. And this is never more true than in the case of scapegoat claims, because if it turns out this claim was hopeless, should never have been brought, and really was a travesty, well, it's better if that's conducted privately through arbitration than publicly through the court process.
Yeah, well said, well said. And something now I want to ask you is something I'm passionate about is, we all have interests. There's a human behind the lawyer that has their own interests or hobbies or passions as well. And as a result of that, you've also founded the Cayman Islands Chess Federation and represented the country, I think, at the Chess Olympiads, which is impressive. So what parallels do you see, if any, between chess strategy and legal strategy?
Well, there certainly are many. Perhaps the obvious ones involve thinking ahead and anticipating what the other side or the opponent in chess will be planning, will be thinking, and then formulating how to respond to that. That might sound a little trite, but it's certainly true. Perhaps less obvious, if we take the words of the former world chess champion Magnus Carlsen, when discussing the strength of his opponents, other players, he would often talk about their ceiling and their floor. In other words, how good are they at their best? What is their ceiling? But how weak are they, or how vulnerable are they at their floor? On their off day, when they're not thinking well, when they can't calculate well at the board, or when they've forgotten a bit of opening theory, whatever the reason, how low is the floor? So when we ask ourselves as professional advisors that question, we might get a surprising answer, perhaps not surprising at all, that most of the time our ceiling might be very high. That's why, in many cases, advisors have risen up to partnership, to leading associations, to having a massive client base, etc. But equally, everyone has an off day, and the floor might be low for many of us occasionally. If we've not slept well, if we're distracted by something, if something's going wrong in our private life, this can affect our work. If our mental health is not quite right at some particular moment. And just in passing there, you asked me earlier about motivation for writing this book. And I explained that I wanted to help advisors avoid the kind of professional crisis that we've been discussing. Um, I would say, and perhaps mental health is overused these days, maybe, but I would say that there is a real risk that if advisors face these kind of claims, they do suffer mental health. I've had specific cases where, I mean, it's stressful for everyone who faces this. That's a given.
Mm.
But I've had particular cases where at least one of the advisors had a nervous breakdown, which simply meant they could not engage with it. They had to
Mm.
go on sick leave. They were done.
Yeah.
And eventually they left their firm, and it was not pretty. So really, this is a real issue. And the fact that professional liability claims can lead to this, I believe, is probably largely unknown or underestimated.
Yeah, and it's so true, isn't it? Because people take their work and their responsibilities, very seriously. And if people are bringing claims against that, that can have an impact because we are all humans. And I would just at this point shout out Law Care, the mental health charity for lawyers, and Elizabeth Rimmer and the great work that they are doing to try and help as many professionals in around the firm. We've had them on the Legally Speaking podcast before in the past, and they're also our chosen charity for the Great Big Legal Offsite, which is a legal event we run. And so I would encourage people to go and support or check out Law Care. There is some help and support out there. Okay, I kind of want to go to some practical takeaways before we wrap up, Shaun. It's been a really fascinating conversation, as I knew it was going to be. That's why I was excited to make it happen. I think the book is excellent. If you could give one piece of advice to junior lawyers or new advisors on avoiding professional liability claims, what would it be?
Make sure your engagement terms are clear, the scope of what you're doing is clear, keep good notes and reflect it back to the client in emails. That's the number one thing. Perhaps sounds obvious, but it could have saved a lot of grief.
Yeah, I think we all know the what we say for assume, and I think that's so true. Constant communication, get it written down, and get those scopes agreed. Very, very important. Okay, beyond the book, you're developing training programs for law firms and others. What do you hope advisors and junior lawyers will take away from these initiatives?
Well, particularly at the junior level, to make professional risk something that's foundational in their career and in a way that's not seen as dull. To be honest, if one speaks of a risk manual, risk training, I can tell you as a practicing full-time professional advisor, it sounds dull. And yet the reality of what we're dealing with here is not dull, it's the opposite. It's actually the flip side of professional success. Because by taking care of the professional risk, you maintain your success. So I would encourage the junior lawyers, junior advisors, to make this integral in their practice as they go forward. And so I'm developing training courses that will exactly do that in a way that is more engaging than simply reading a textbook or checking a policy. Often the claims don't come from failing to follow a policy anyway, although, of course, I'm not encouraging anyone not to follow the policies. I simply mean that the claims often come from real life situations. And so the training courses are aimed at really real world insights into where these claims come from and how to then go through your entire career with that in the back of your mind, developing that sixth sense. It's not to say being overly defensive in your advice. You still need to give robust advice, but simply to protect yourself and your firm as well at the same time. So as I would offer to firms that in time over the next few months, when I develop these courses, they will be available to roll out sort of on a licensed basis across your practice so that juniors and even more senior advisors can benefit from that.
Yeah, I like that. And I like that you're making them engaging and real. And so people can kind of really learn from, scenarios and stay engaged. I think it's wonderful. Shaun, this has been fantastic. Really powerful insights shared today and some wonderful stories. Really enjoyed the conversation. For folks, if they would like to know more about you or indeed get their hands on the book, where do they need to go? Feel free to share any website links or any socials. We'll also share them as well.
Yeah. Thank you very much, Rob. It's been a great conversation. Thank you for hosting me. They can find the book on www.advisorsminefield.com or through usual channels. It'll be on Amazon. The audiobook will be available shortly on Spotify and other platforms. So it's available in 3 formats: in ebook, PDF, or Kindle, in a physical form, or as an audiobook. And likewise, if firms wish to roll out the book across their advisory staff, then that can be done on a bulk basis at a discounted rate as well. So likewise, just send me a message, direct message on LinkedIn, and I'll get back to you and be glad to be in touch.
There we have it, folks. So thank you so much once again for joining me today, Shaun. Really enjoyed it. And for those watching, key takeaways from the Advisor's Minefield. Number 1, even elite firms face lawsuits. Pedigree offers no immunity. Scapegoat claims are real. Point number 2, document everything every time, as Shaun was alluding to in some of his final points. And then number 3, spot the red flags. From rushed deadlines to fuzzy engagement letters, make sure you spot the red flags. So again, reminder, Shaun's new book, The Advisor's Minefield, Why Professional Firms Are Sued and How to Protect Your Practice, is out now in hardback, ebook, and audiobook, as he mentioned. So do go over and head to www.advisorsminefield.com to learn more and access all the resources, including Shaun's practice defense checklist. So for now, from all of us on the Legally Speaking podcast, proudly sponsored by Clio, thanks again for tuning in. Until next time, over.